Well, welcome. Welcome. My name is Mark Movsesian. I'm the director of the Center for Law and Religion, and along with my colleague Mark DiGirolamo, who's somewhere out there, who helps run the center, I'd like to welcome you all to tonight's event. Tonight's event is sponsored by the Center for Law and Religion at St. John's, which was founded in 2010 to examine the relationship between religion and the state, the concept of law in different religious traditions, and also to further the Vincentian mission of the law school by promoting a dialogue on law and religion in the academy and in the wider community. Tonight's event launches the Center's new research initiative, the Tradition Project. The basic objective of the project, which as far as we know is the only one of its kind in the academy today, is to develop a broad understanding of what tradition, the received wisdom of the past, continues to offer contemporary law, politics, and culture. Over 3 years, the project will bring together public figures, scholars, judges, and journalists for lectures and workshops on the meaning and the relevance of tradition. Work related to the project will include books, journal articles, and curricular development. The project aims to cultivate a greater appreciation for tradition in the academy and in the wider community, and in doing so, to inform law and politics and culture in the United States and across the globe. Tonight's lecture kicks off the first of 3 major conferences the project will sponsor, this one on the theme of tradition in law and politics. Future sessions planned for 2017 in New York and 2018 in Rome will address tradition and culture and tradition and the global clash of values. In addition, the project is hosting other smaller events throughout the year, both in New York and in Europe. The project is only one of several programs the Center sponsors at St. John's campuses in New York and Paris and Rome. These include international conferences and colloquia that have featured speakers such as Pope Francis, who gave the keynote at our 2014 Conference on Religious Freedom in Rome, and Supreme Court Justices Samuel Alito and the late Antonin Scalia, who've taught seminars for our students, as well as leading scholars from across the globe, including tonight's speaker. The Center also hosts the Law and Religion Forum, an award-winning blog that features commentary from Center faculty and guests on law and religion issues in the news and in the courts. We have folders available tonight with information. We put them on the chairs. The folders have information about our center and our programs, and I certainly encourage you to contact us with any thoughts you have. I think, Claire, we forgot to put envelopes in the folders this time, but well, you know where to reach us. We've had a lot of help for tonight's event. First and foremost, the Tradition Project has received generous grants from the Lind and Harry Bradley Foundation and from the Achilles and Bodman Foundation, for which we're most grateful. The project would not exist without those benefactors. I'd also like to thank Dean Michael Simons, who couldn't be here tonight because of a family obligation, who has been a steadfast supporter of the Center and our work. I'd like to acknowledge Mr. Matone, who's a university trustee who's with us tonight, who's also been a great supporter. And I'd like to thank members of the St. John's administration, including Brian Woods and Ed Kling and AJ Buckley, and especially Claire Policino, who's worked extremely hard behind the scenes to put this all together. Now, to introduce our lecturer, who will speak tonight on the subject of tradition and the Constitution. Michael McConnell is the Richard and Frances Mallory Professor and the Director of the Constitutional Law Center at Stanford Law School, as well as a Senior Fellow at the Hoover Institution. He's a leading authority on freedom of speech and religion, as well as many other aspects of constitutional history and constitutional law. He's the author of numerous articles and the co-author of 2 casebooks, The Constitution of the United States and Religion in the Constitution. He's co-editor of a book called Christian Perspectives on Legal Thought. Since 1996, he's been a fellow at the American Academy of Arts and Sciences. Before joining Stanford in 2009, Professor McConnell served as a judge on the U.S. Court of Appeals for the 10th Circuit. He's argued 14 cases in the U.S. Supreme Court. He's been a professor at the University of Utah and the University of Chicago Law Schools, and a visiting professor at Harvard Law School. He was Assistant General Counsel at the Office of Management and Budget and Assistant to the Solicitor General in the Department of Justice under President Ronald Reagan, and a member of the President's Intelligence Oversight Board. He served as law clerk to then Chief Judge Skelly Wright of the U.S. Court of Appeals for the D.C. Circuit, and to Justice William Brennan of the U.S. Supreme Court. He's a graduate of Michigan State University and the University of Chicago Law School. Professor McConnell, we're delighted to have you with us tonight. The floor is yours.
So, what are we here to talk about? We're talking about tradition. Tradition, I would define as social practices and mores, and for this crowd, especially legal rules, whose authority derives from long-standing practice. This is opposed to rules and mores that are imposed by command from some kind of a sovereign authority or perhaps an expert authority. And it's also opposed to practices which are followed because of a conviction of their rationality, their correctness, or their utility. Traditions also have the characteristic that they are not frozen in time, but rather evolving. Tradition is not antiquarianism. What tradition doesn't value things because they're old, it values things because they have survived, that they've survived the test of time. So Igor Stravinsky is one of my true favorite modern composers, but what he has to say, I think, is a really good antidote to this misunderstanding of tradition, because no one, I think, would accuse Igor Stravinsky of being hidebound or antiquarian. I assume most people in an audience like this are familiar with one of the greatest scandals in the history of the art world, which was the initial performance of Stravinsky's ballet, The Rite of Spring, by the Ballet Russe in Paris in 1913. Before this crowd, this audience of the Haute Monde, they're all, these are not dyed-in-the-wool, old-fashioned Pecksniffs. These are the creme of the avant-garde Parisian world. But confronted with this music and this dance, a riot broke out. There are all kinds of accounts of this that are somewhat different, but people were hitting each other with canes. They were rioting. They were throwing things at the stage. They were chanting. It was a full-bore tumult in response to this premiere. And so that's Stravinsky. He's here's what he has to say. He says, and I quote, "A real tradition is not the relic of a past that is irretrievably gone. It is a living force that animates and informs the present. Far from implying the repetition of what has been, tradition presupposes the reality of what endures. It appears as an heirloom, a heritage that one receives on condition of making it bear fruit before passing it on to one's descendants." There's a lot in that, right? So, in particular, tradition, we're not talking about something that was way back in the past. We're talking about something that has endured. I really like this idea of an heirloom that we actually use in the present, fruitfully use in the present, and that's what entitles us to pass this on to the next generation. It is the fact that it has endured is proof of its value, right? But it's the value that really matters, and its use and its capacity for being transferred from one generation to another. I think he knew exactly what he was doing with those discordant notes and those pulsating rhythms that so upset the crowd in Paris. So if we've given something of a definition of tradition and a few characteristics that tradition has, should note that the force of tradition varies quite a lot from society to society. That in some societies, the force of tradition is very strong and rigid. So, for example, I am told by no less an authority than my wife, who teaches AP art history to high school students, that for 2,500 years, the great monumental art of Egypt did not change. Right? 2,500 years in which a particular artistic tradition continues. Not that they weren't producing new things. They were producing great new things, but the style and the manner of presentation and so forth remained the same. There are other cultures, not very many of them actually, but some cultures that are at the opposite extreme, that are antipathetic to the idea of tradition. If it's old, it's uncool, right? We chase after the latest thing. It's like if you go into the drugstore and you're looking for detergent, new is the word that they blazon at the kind of chevron in the corner of the package. I think that our culture, by which I mean not just the culture of the United States, but of the West in general, especially the Anglo-American West, but the West in general, is one in which tradition is powerful, but it's treated as kind of a default. That is to say, it can always be followed. It is always following tradition is always a good reason for acting, but there may well be more powerful reasons that outweigh it, right? And so sometimes, indeed not rather often, we will depart from tradition, but we won't do it lightly, and we won't do it without reason. It's a strong presumption, a default position. It's maybe this is frivolous, but I'm inclined to think of it a bit like the pirate code from the movie from 10 years ago. It's more like guidelines than rules, the pirate code. Although actually I've read enough about the history of real pirates to be able to tell you that the actual pirate code is one of the most interesting examples of a non-governmental set of rule-based governance rules that we've ever seen. It's really quite a remarkable phenomenon. It's quite a bit more than guidance. And so tradition is not something that is impervious to change. It's something that's constantly changing, constantly evolving, but not in convulsive ways. It changes the word that our great founder James Wilson, probably the greatest lawyer among the founding generation, the first law professor at a university in America, the word he uses for this is insensibly. That is, it changes insensibly, not deliberately, not as a matter of trying to produce some a big change, but alteration in light of circumstances. And it seems to me that there are three principal sources of change. I think of the little bits of sand that get in the oyster that produce the pearl. Well, these are the little bits of sand that get in the tradition, and sometimes they produce a pearl. Now, sometimes they're just sand, they're grit, but they may produce a pearl. They may produce change, which actually is going to improve the lot of humanity. One of these sources is the outside world, a confrontation with people, new and different people who are thinking differently, who have different ideas. Perhaps they move to your country, maybe you explore and you encounter them, but those ideas from outside will begin to present an alternative, and you begin to think, well, why do we do the things that we do? It isn't it isn't just natural. Obviously, there are alternatives. We have to think about this. And that can produce change. A second source is that new problems and issues can arise. Technology often does this. A new technology comes along, and lo and behold, long-standing traditions turn out not to be adequate to deal with the new issues, and we have to do something about that. Back at Stanford next week, we're going to be hearing a paper about how the advent of cheap, meaning inexpensive speech over the internet is forcing us to reevaluate certain aspects of long-standing tradition in the area of free speech principles. And then finally, there are internal contradictions and flaws in the tradition that may emerge, may seem more serious. We can paper over differences and contradictions and flaws for a while, but sometimes they begin to loom larger and we have to deal with them. I think a great example of this is the issue of slavery in the United States, where there's a strong, long-standing tradition permitting slavery, and Christianity is a contrary tradition that for a long time they managed to not think very much about the contradictions, and people were able to paper over those differences. But as the decades of the beginning of the 19th century wear on, those contradictions are more and more urgent and difficult and important, and the result ultimately is a reconsideration of one side of that contradiction. So if this is what tradition is like, what it looks like, why follow it? Why not just do in any individual circumstance what appears to be best? Why don't we just have a rational calculation of utility about everything? Well, one thing that tradition does, one thing that it contributes, is that it provides a social coordination function. Now, this is obvious when we're thinking about things like manners, right? You want to know where you stand. We were told in an email that men needed to wear jackets to this institution tonight. That's very helpful, but if we had a well-operating world of tradition, they wouldn't have had to send us an email. We'd have known. Right, and it's good to know. I just traveled a bit in Italy, and one of the things I wanted to know is, what are tipping practices? What time do people eat dinner in this country? These are conventions, these are traditions, and they help us because we want to be coordinated. Language is very much like this. Speed limits, great example of a need for social coordination. And most importantly for our purposes, the common law is like this. But social coordination doesn't really answer the full question, because it can be achieved as well by top-down command and control regulation. That's another means of social coordination. We could have a rule book. We could have emails telling us we have to wear jackets instead of traditions that tell us we ought to be wearing jackets. How does tradition differ from top-down command and control regulation? Well, one way in which it's different is because it partakes more of democratic consent. It's a postulate of our legal system that all legitimate government has its origins in the consent of the governed. Well, here in the United States, we do not have a priestly class. We do not have mandarins or overlords recognized as smarter than we are. Instead, we have a largely egalitarian culture, and there are two ways in which norms can be established in such a culture. One is through representative government, and the other is through custom or tradition. And we do both, but they operate in slightly different spheres. Back to James Wilson again. Wilson said that custom is the most significant and the most effectual source of law. That is more significant, more effectual even than legislation or statute. And this may not be quite as true today as it was when he was writing. because custom, and this is what I'm really quoting him for, it, quote, contains in it internal evidence of the strongest kind that the law has been introduced by common consent. And so custom tradition has this advantage, or at least this difference over top-down regulation, that it's more democratic, it's more consensual, it's more broad-based. And indeed, in the Anglo-American constitutional history, in our tradition, custom and tradition in the form of the common law were the most important defenses that were raised against the absolutist tendency of kings. So, as James I and Charles II and their sons and brothers were trying to convert Britain into a modern absolutist Enlightenment, post-Enlightenment monarchy on the continental model, like their good friends were doing in France and Prussia and Spain and Russia. It was the common lawyers like Coke and Hale and others who invoked long-standing custom and tradition in the form of the common law as a barrier against these absolutist tendencies. So the custom and tradition were the more popular, I hesitate to say democratic in the context of early Britain, but somewhat more popular, somewhat less royalist, at least, sources of authority that could be held up as in contrast. And a great deal, I think, of our constitutionalism continues to have this feature that norms that have come about through custom and tradition are still protected against the forces now of democratic government rather than of sovereign government. And so we see that the Constitution always speaks of rights as if they pre-exist the Constitution and come from some other unidentified source, right? So the Due Process Clause tells us that no person may be deprived of liberty without due process of law. Well, to say that they can't be deprived of liberty suggests that they had the liberty before, and now it can't be taken. Well, that liberty is not created by the Constitution. It comes from somewhere else, right? And one might say it comes from natural law, and one might say that it comes from long-standing custom and tradition, and one might actually be hard-pressed to tell the difference. One commentator noted that whenever John Locke, the great political philosopher John Locke, spoke of natural law, he ended up speaking as if of the English common law, that the common law and the natural law just tended to merge in their minds. And so the idea that it's not just that tradition has this more decentralized, more popular, more democratic origin to it, but it's actually in opposition, in potential opposition to a more authoritarian mode of government. And secondly, in addition to having more to do with democratic consent, tradition also at least has a good argument for being a better way to get at good answers, that is wisdom to it. Now, there's a kind of Darwinian logic. Again, I do want to warn you against the idea that old is good, right? It isn't that in the midst of time they were smarter, that they were better. It's not that the past has any, the more you study history, you more realize that they were just as foolish as we are most of the time, with a few examples, and we even have a few exceptions, increasingly few exceptions. But that it has nothing to do with the greater virtue of the ancients. it has to do with this kind of Darwinian logic, right? That traditions survive because they accomplish something. The great common lawyer, Sir John Davies, wrote, and I have to read this to you because I think it so captures the logic of the system. He says, when a reasonable act once done is found to be good and beneficial to the people and agreeable to their nature and disposition, then do they use it and practice it again and again. And by often iteration and multiplication of the act, it becometh a custom. But a custom doth never become a law to bind the people until it hath been tried and approved time out of mind, during all which time there did not thereby arise any inconvenience. Right? And so I think of this as Darwinian because you have a set of, you've got a gene pool, that's the body of tradition, and then there are going to be some mutations, and those mutations are going to be accepted, and if they produce good things, as Davies says, if they are good and beneficial to the people and agreeable to their nature and disposition, then they're going to be repeated again and again, and they will become the rule, and eventually even in the common law system become a law. So the Darwinian logic of tradition is that we'll produce a better set of rules this way than we would by just as a matter of theory trying to come up with good ideas for ourselves. None of us are that smart. So this is actually what I call the Hayekian logic. So there's a Darwinian logic, and then there's also a Hayekian logic. After Friedrich von Hayek, the great Austrian economist and political philosopher who won the Nobel Prize in economics. And the most important ideas of his work have to do with the notion that any one person or any one group of people is unlikely in this extremely complicated world of ours to be able to understand all of the ramifications and predict accurately the consequences of any particular rule, and that a superior form of social organization, at least in contexts where it is possible, is what he calls spontaneous order. And he has a lot of the persuasiveness of this, some people don't find it persuasive, but a lot of the persuasiveness of this is from examples. Language is a particularly good example of this, right? Where you don't have, we don't have something like the French Academy that votes on whether particular words are going to be used and so forth. There are no authorities. This is entirely a decentralized process, and yet, we can speak English to one another and understand one another. It is not random. It is not pure happenstance. It changes, but we can even talk to our grandparents, and we can, and when we read what the framers wrote, there may be a little word usage we need to understand for the little change, but by and large, language works this way as a spontaneous order, and Hayek argues that so too does the common law, and I think so the argument is both has to do with experimentation, but also has to do with the limited knowledge of any one person and the superior knowledge of many different individuals acting. And then a further advantage, in addition to democratic consent and perhaps wisdom, is the adaptability of tradition. And again, this is in contrast to such things as rules and statutes. Now, rules can be changed and statutes can be amended. They're not impervious to change. But I think anybody who has observed Washington or even been around other bureaucratic institutions like, dare I say, universities, is aware of just how tenacious rules and statutes actually are. It is very difficult once something is on the books to get it changed, even when it's manifestly no longer serving useful purposes. It's even, I think, this tradition is in this sense is even more adaptable, this is going to be controversial, than rationality. When you engage in rational thought, when a human being engages in rational thought about utility or correctness, it is very easy for that person to disregard the messy details of actual quotidian reality in favor of their theory. I certainly have known people like this. I may even be like this. I think it is, and so I think that we're going to be sometimes allowing the forces of experience and change and tradition to influence that is going to get us out of even the intellectual rut. So the James Wilson again, if I may. It is a characteristic of a system of common law that it be accommodated to the circumstances, the exigencies and conveniencies of the people by whom it is appointed, as these circumstances and exigencies and conveniencies insensibly change. So this idea of tradition, and especially its legal manifestation in the common law, is one that has the advantage of adaptability. So we've talked about definitions, we talked about some characteristics and some advantages, at least if one wants to defend a large role for tradition and social organization. Where do we see this? Well, I mean, we see tradition very powerfully in society as a whole, and such things as manners and language and artistic styles and all kinds of things. I'm not going to talk any more about that. You know, if I were a sociologist or an art historian, that's probably what I would wallow in, but I'm going to move on to the juicy stuff, namely law. And then we see tradition in law in general, and in particular, we see the importance of tradition in constitutional law. Now, law in general, I think this is somewhat obvious for those of us in the Anglo-American legal tradition, because the common law understood itself as being based upon traditions, that is, long-standing practices. Now, a modern law student might not understand that, might find that a very puzzling statement, because today, and actually for a good period of time now, maybe going back to the legal realists of the 1920s, common law has a quite different understanding. If you ask a group of modern law students what is common law, they'll say, well, that's judge-made law. And what's a good example of judge-made common law? Well, how about the California Supreme Court when the great Justice Roger Traynor, made up a new rule about something because he thought it would be a good idea, adopted some new rule of products liability because it would serve his understanding. Actually, I think we now believe mistaken understanding of the law and economics of insurance, and so the only difference between common law and statutory law is that statutory law is voted on by representatives and common law is voted on by judges, but they're both seen as a kind of a voted on positive law. Common lawyers of the framing period and for another 150 years after that would not have recognized that description. They did not think that the common law was judge-made they thought the common law was judge discovered. There may be a bit of fiction in this, but fictions are often aspirations for what should be, how the actors in a system should think about what they're doing. And what they believed is that judges were the voice of the law, but not the creators of the law. That what judges are doing is looking out at our society and in an objective way, more like sociologists than like policy nerds. As sociologists, they're looking out in the society and asking themselves the question, what are the rules and norms and practices and understandings that a reasonable person in our society would bring to this kind of a conflict? Right? And in particular, in a free society, largely a free society like ours, what are the rules of obligation and liability, my rights toward you, my obligations toward you, what types of rules and obligations would one free person owe to another free person? That's basically what's going on in a common law system in a free nation like the United States or even Britain. So today, common law has a somewhat different understanding than it once did. I'm talking about the older common law. And this is related to the concept of precedent or stare decisis, which may look like a species of tradition, and I think sort of is. So precedent or stare decisis is the idea that a judge should decide the case that is now before him or her on the basis of past decisions. You can see how similar that is to the idea of tradition, and where instead of figuring out independently what the right answer is, you just decide the case the way such a case has been decided in the past. It's a kind of tradition. But today, and for, I think really since the mid-19th century, this has been going on for a very long time, stare decisis has taken on a slightly different meaning, which is the following of the most recent case. So stare decisis precedent during earlier centuries and at the time of the founding meant that judges are bound by a line of cases. That is, when you see a whole series of cases with independent judges reaching consistent results in a lot of different ways, and especially if those judges are of somewhat different temperaments, that gives authority, and at that point you follow it. But today, 5-4 decision of the Supreme Court, and we've got stare decisis. I believe it is true. I think the rule is this, that past decisions of the Supreme Court govern all subsequent cases raising the same issue, except where they don't. I think that's the rule, and I think they always follow it. Justice Alito was before a judicial conference, and I was there, and he said, he referred to the doctrine of stare decisis, and he said that's Latin for following precedent when we feel like it. But again, the older view was that it was a line of cases. No one decision would do it. Lincoln, in one of his analyses of the authority of the Dred Scott decision, put this extremely well, I think, where he did recognize the authority of the Supreme Court over the particular judgment in the particular case. That is the case affecting Dred Scott and his wife Harriet and the children. but not necessarily the rationale of the court to govern other cases. But this is what he said. He said that I'm quoting now, Supreme Court decisions have precedential force when fully settled, he said, but not a single divided decision. Quote, if this important decision had been made by the unanimous concurrence of the judges and without any apparent partisan bias, or if it had been affirmed and reaffirmed through a course of years, then it might be, and he says, factious or even revolutionary not to acquiesce in it as precedent, but not just a single 5-4 decision. The modern idea of stare decisis is really a species of positive law and not of tradition. When we say that a 5-4 recent decision is authoritative, we are really not referring to anything that is recognizable as a species of tradition, and it has none of the advantages that I've been talking about. It may be right, there may be good reasons for it, but it doesn't have those advantages. Instead, it is simply an an order from our sovereign. Happens to be an unelected sovereign, but an order from our sovereign. Nonetheless, when we look at modern constitutional law, we see the authority of tradition really all over the place. This is one of those things where as soon as, have you ever noticed if you learn about somebody's name, you begin seeing it in the newspaper, or once you become aware of something, it begins to be everywhere. I think the role of tradition in constitutional law is a little bit like that, because in most law schools in constitutional law class, we learn about the approach of textualism and originalism, which is a species of positive law. That is, the framers had sovereign authority. They set down certain rules, and therefore we ought to follow what they said and what they meant. I mean, that's basically the logic behind textualism and originalism. And then we also learn about something like living constitutionalism or legal realism, in which what the judges do is that they look around at the modern world and they tailor the rules to what they think are the circumstances of the day. And those are kind of the poles around which constitutional decisions revolve. Tradition usually gets left out. And yet when you look for it, you see that there are large swaths of modern constitutional law in which long-standing practice, and I'm not here referring to stare decisis, but long-standing practice of legislatures, of Congress, of the president, and so forth, are given considerable authority. One of the most recent and conspicuous examples of this was the Noel Canning versus National Labor Relations Board decision from a couple of years ago, which had to do with the meaning of the Recess Appointments Clause, in which there is an extremely plausible textualist, originalist claim that the president may not make recess appointments when the recess occurred while the Senate is in session. Indeed, that seems to be what the Constitution says, although it may not be 100% pellucid. But it turns out that at least beginning at least as early as the Monroe administration, and maybe with some precursors even to that, that for decades and decades, most of American history, presidents have made recess appointments even to those vacancies, so long as it's vacant during the recess of the Senate. This has very large practical implications for presidential power. And the Supreme Court, in an opinion by Justice Breyer, looked to that long-standing historical practice and said that has given given meaning to the Constitution, and we will follow it. Right? And so this is giving quite strong force to tradition, to longstanding practice, even in the face of pretty good textual arguments to the contrary, although I do stress that the court did say that the words of the Constitution were not clear. I think if the words are clear, then subsequent practice is not going to be able to dislodge it. There was a decision just a few days ago by the D.C. Circuit holding that the structure of the Consumer Financial Protection Board as an independent agency with only one head is unconstitutional, in which a large part of that reasoning is very similar to the Noel Canning reasoning in that it's based upon very long practice in which independent agencies are always multi-headed. That is, if you're going to be independent of the president and not subject to democratic accountability, there has to be a little bit more democracy built into the agency itself through multiple heads. Footnote, I'm not entirely persuaded by the reasoning of that, but I just point to it as a very recent example of a quite significant opinion that rests upon longstanding practice. And when you look back a bit, the most important constitutional case of the the Marshall Court, the John Marshall Court, McCulloch against Maryland, that's the constitutionality of the Bank of the United States. The opinion begins that this question can scarcely be considered an open question. Why? Because by that time there was 40 years of practice in which President Washington and it had been debated. Lots and lots of folks had all decided in favor of the constitutionality, including James Madison, had ultimately signed the bill with the Second Bank of the United States, notwithstanding his constitutional opposition to the first one. Well, this idea of looking to longstanding practice to interpret the Constitution goes, at least in some segments, by the fancy terminology of liquidation. This is the term that James Madison attached to the practice. In Federalist 37, Madison wrote that all new laws are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. And so adjudications are presumably what goes on in court. What are the discussions? Well, how about debates in Congress and other bodies over the meaning of the Constitution? So the idea here is that the ambiguities and vaguenesses of constitutional terminology get hashed out and liquidated in the end, meaning ascertained, meaning made certain. The Madison made clear that, well, the Constitution could be, quote, expounded. It could not be controlled or varied by these acts. It's only a matter of interpretation. It is not a matter of constitutional change. And so this is not to be confused with theories like that of our friend Bruce Ackerman at Yale, that the Constitution can actually be amended through constitutional moments of this sort, but only that its ambiguities can be interpreted. So this actually, I think, fits quite nicely with the original theory of the founding generation about what they were doing. Gordon Wood, one of my favorite historians of the American founding, wrote that the founders, quote, sincerely believed that they were not creating new rights or new principles prescribed only by what ought to be, but saw themselves claiming only to keep their own privileges, the traditional rights and principles of all Englishmen, sanctioned by what they thought had always been. So in addition to this sort of liquidation of separation of powers issues and so forth, another major area in which we see the use of tradition is with respect to individual rights, and especially Well, actually, both unenumerated rights and, to some extent, enumerated rights. Let me begin with the enumerated rights. Take, for example, freedom of speech, plainly enumerated right in the First Amendment in the Bill of Rights. But what does it mean? What are its contours? It can't just mean absolutely, you can't say absolutely everything you want to say. My friend Stanley Fish here wrote a wonderful article in which he said there's no such thing as freedom of speech, and it's a good thing too. But in any event, it doesn't protect everything you say. What does it protect? Well, what the First Amendment says is that the freedom of speech, meaning the freedom to speak, not speech, but the freedom of speech, cannot be abridged, meaning reduced. And so what the framers did is they took then existing practice as their baseline and said, we're not going to get any worse than that. Now, maybe freedom of speech is going to be increased in various ways, but it's not going to be abridged. Or take the Fourth Amendment, no unreasonable searches and seizures. Well, what's reasonable or unreasonable? The Supreme Court has unhelpfully told us that this has to do with reasonable expectations of privacy. But where do we get expectations of privacy? We get them from past practice, right? Something is reasonable if it accords with the norms that we expected to apply to it. And so in these ways, longstanding practice can give the real substance even to enumerated rights. But as to unenumerated rights, the idea of longstanding practice, I think, is essential. I mentioned the wording of the Due Process Clause, but if we're talking about the modern court gives us unenumerated rights under the unlikely rubric of substantive due process, which it's too late in the evening for me to go into the full diatribe about this. I can refer to hundreds of pages I have written on this subject. But the punchline is this, that to the extent that there are unenumerated rights in the 14th Amendment, it really would seem to rest in the Privileges and Immunities Clause, which, after all, does say no state shall make nor abridge the privileges or immunities of citizens of the United States. So that is at least about making and abridging rights that are abridging rights. Well, what are those privileges and immunities? The framers of the 14th Amendment referred frequently to an early case having to do with the Privileges and Immunities Clause of Article 4, Corfield versus Coriel, which said, a long quote, but said these are rights that have at all times been enjoyed by the citizens of the several states which compose this union, or by the citizens of all free governments. So it's not a matter of moral philosophy thinking what rights they should have been enjoying. It's the ones they actually did enjoy. In other words, an invocation of the traditional practice with respect to rights, and now protected in the 14th Amendment. And the Supreme Court embraced this way of thinking in a case called Washington versus Glucksberg, in which it said that for thinking about what unenumerated liberties are going to be constitutionally protected, we look to what are objectively speaking protected by the longstanding practices of the people. Now, you may be thinking, well, wasn't there a case called Obergefell last term, and doesn't that sort of throw all of this out the window? And less said about the logic of that opinion, the better. But I do want to say this, that as we think about Obergefell and teach about Obergefell and write about Obergefell, it would be helpful and more consistent with the line of cases to think about Obergefell as an equal protection case rather than an unenumerated rights case. To the extent that we think about Obergefell as saying that there is this institution of marriage, and that is not being changed, all that we're doing is insisting that all people, including same-sex couples, have the same right to that same institution, then I mean, there may be logical flaws in that, maybe problems with that, but it will not turn Obergefell into a wrecking ball for the idea that our rights and liberties are rooted in the customs, long-standing customs and practices of the people. The alternative to the long-standing practices of the people, of course, is the moral intuitions and preferences and, dare I say, biases of a current 5-justice majority on the Supreme Court, something which I doubt, behind the veil of ignorance, if we had no idea who the justices were going to be, very many people would vote to have our system of liberties in the United States depend upon their own private preferences. All of the advantages of use of tradition as form of social organization suggest otherwise. So I'm going to conclude with that. I do say, as maybe, how timely is this conference? It is extraordinarily timely, but kind of in a sad way. I have to, whatever happens on the first Tuesday of November, a great deal of damage has already been done to longstanding practices of our democratic system, and a lot has been lost or destroyed, and I almost want to just say discarded for no good reason. And I fear we may be in for the opposite of Igor Stravinsky's Rite of Spring. I think there are going to be plenty of discordant notes. There are going to be plenty of pulsating rhythms. There may even be a dance of death, but I don't think we're going to have Stravinsky's vision of rebirth and renewal. So in the tumult and riot that may come about as a result of the performance of this ballet that our democratic system has brought upon ourselves, I just hope we don't smash the heirlooms. It may be that we do not, for a space of time, use those heirlooms in a fruitful way. But our institutions are very soundly constructed, and our traditions are quite healthy. And with study and thought and good scholarship, such as I'm sure we're going to be witnessing over the next day and a half, we can preserve those heirlooms and pass them on to the next generation. So thank you for this conference.